All right. Why don't we begin? Afternoon. Couple of announcements. I expect that we will fully catch up to the syllabus by today, but I do have one announcement. We will not be holding class this Thursday. So whatever we're going to cover this Thursday is going to be pushed over the following Tuesday. I have to give a lecture at Emory Law School, and the only way I can make the flight is to leave before class normally would start. But there's no reason to be concerned because, as I mentioned before, I built time into the syllabus to account for times that we would have to reschedule class. We have regular office hours tonight from 6 to 8. If anyone who wasn't able to sign up for the slots with me yesterday want to come during office hours and talk about their chart, if you want to do it while other folks are on the screen, that's fine with me. If you prefer to do it one-on-one or in a small group, I'm going to be putting up more slots, either starting this weekend and next week. And indeed, if you want to meet with me, or if you wait to meet with me until next week, by then your chart probably should be complete. Having said that, I'm glad that I was able to have all these sessions yesterday, because it sort of gave me a sense of the pattern where some of the issues are, which I want to talk about today very briefly before we turn on the cases that we're going to cover today. So today we're going to talk about Schaefer, which I began to talk about last Thursday. We're going to talk about Burnham, and we're going to talk about the so-called technological contacts jurisdiction. And by the time we do that, as I said, we should be caught up with the syllabus. So let's talk about some of the things that I've been seeing in the chart simply by way of providing you with some advice in terms of where to go next. The first thing I should say, though, is that of all the folks who met with me, I was gratified to see that, for the most part, folks have got the structure down. The analysis is correct, except that the main theme that came out yesterday was that you need to put a bit more information in your chart. So let me give you an example, information that you already have. So most folks, for example, said that one of the first things to do is to talk about presence, right? And they either said no or yes. But then the yes box was empty and folks moved on from that. What I would encourage for folks to do is not to just say yes, but to say yes if, and then list the things that you already know, right? So you already know that a citizen of a state, and I know there's a separate box for citizenship, but I just want you to remember that a citizen of the state is always deemed to be present in the state, even if that citizen is not literally present in the state, right? The other thing that I would put in the box is the difference between the presence of a person and the presence of a corporation, right? A corporation is not only deemed to be a citizen of the state where they are incorporated and of the state where they have their principal place of business, right? That corporation is also deemed to be present also in the state where they're incorporated and in the state where they're doing their principal place of business. Next, I would put the information that presence can also happen even if, as we're going to talk about Schaefer, Burnham, that you're there temporarily. But it only applies to people, not to corporations, right? Finally, I would also acknowledge in that box that presence is deemed to apply to in-rem jurisdiction. In other words, a piece of property that is located in the state, right, where the subject matter of the lawsuit is the property is deemed to be present. So that's an example of where you want to essentially put in that box information that is useful, that helps you recognize when presence can happen rather than simply say yes. So that, and it can happen in other instances as well. Another example is when you have the citizenship box. Okay? In the citizenship box, right? Instead of saying yes to a citizen, you might have a citizenship box, yes if you're a person. What I want you to put for now, even though we don't have the full definition of it, is that you're deemed to be a citizen if you domicile in the state, not if you reside in the state, which we're going to talk about in a couple of minutes. Okay? Next, if you're a corporation, you're deemed to be a citizen of both places, if it's separate, where you're incorporated, and also where you have the principal place of business. That box is going to get expanded a bit more when we talk about other things that are non-natural persons, that are not corporations, like charitable organizations or like partnerships. For now, simply fill it in to account for it. Second thing that I've noticed in the chart is that when folks get to the question of, is there a minimum contact? Folks sometimes say yes, and then they say, is there purposeful availment? Is there foreseeability? I want to at least be very clear that the question of minimum contact is not a separate question that you answer yes to, and then ask for purposeful availment and foreseeability. Minimum contact is merely the expression of the test, that the defendant must have sufficient minimum contact with the foreign state such that it doesn't offend traditional notion of justice and fair play to exercise jurisdiction. Okay? It's not a yes or no question. In order to answer that question, then you have to analyze three elements. You have to ask yourself, okay, did those contacts occur through purposeful availment, voluntarily? And the reason why that's important is that if those contacts didn't occur voluntarily, it doesn't really matter how many there are. There's no minimum contact. Okay? I think sometimes the phrase minimum contact is misleading because you think it has to be with the number of person, right? Next, you ask yourself, well, okay, the person may have entered into the contact voluntarily, but are the nature of the contacts such that the person would anticipate or would foresee being so? Because sometimes you can contact the foreign state voluntarily, but it happens at such a sort of quick, transient way that you could not foresee being so. And the last question that you analyze is the fourth question, the relatedness test. That, yes, you did it voluntarily, yes, you could foresee, but let's make sure that the lawsuit itself comes out of those contacts. And the example that I tried to give you last week, and I've talked to you individually yet last night, is imagine if Ford was being sued in Minnesota by an employee in its Michigan headquarters because Ford fired the employee, and the employee said, you fired me because of my age, so I'm going to sue you for age discrimination. But the employee, instead of suing Ford in Michigan, which clearly they could have jurisdiction over Ford because Ford is as its main headquarters in Michigan, and or the action occurred in Michigan, that they decide for whatever reason to bring the lawsuit in Minnesota. And the arbit is that, well, look at how many cars you sell in Minnesota. Look at the fact that you have dealerships in Minnesota. Look at the fact that you have repair shops in Minnesota. Look at the fact that you advertise in Minnesota. Look at the fact that you seek customers in Minnesota. Right? None of that would matter because if I look, it's purposeful availment, it's foreseeability. The lawsuit, which is an employment discrimination out of Michigan, doesn't relate to or arise out of those contacts. So it's not as if you say yes to this and then these are separate tests. These are the sub-elements of that test. The next question folks have asked me is, what about all these other factors that Burger King listed about weighing the relative burden between the defendant and the plaintiff, the interest of the foreign state? These are policy considerations that are taken into account in examining the fairness analysis. But it is not really different. In other words, if you conclude on the minimum contact test, there's purpose of availment, there's foreseeability, and it's related, you're not going to decline jurisdiction because it's a little bit burdensome on the defendant to come to that jurisdiction. Just so we have to understand. The next thing I want to also emphasize to those of you working on your chart is that your chart must account for general jurisdiction, long-arm jurisdiction. The fact that it's almost never the right answer doesn't mean that you don't need to recognize it when it is present. So please understand that in constructing the chart, what you are really concerned about is that you're trying to have it clear in your head and on the page, the circumstances under which you know by the time you reach the bottom of the flow chart, there is general jurisdiction. Okay? And we know that happens when it's a citizen being sued, the person is present, or in this sort of weird subset of corporate registration where you give up all jurisdiction. Right? General jurisdiction doesn't necessarily happen in consent situations, because in consent situations you're consenting to something specific, not general. Right? Secondly, you want to understand the exact circumstances under which you are concerned about specific long-arm jurisdiction, which you know only happens in instances, right, where the person is not a citizen, the person is not present, and you're engaging in minimum contact analysis. And minimum contact analysis, as we know, based on today's cases, occur automatically in two situations when those conditions are met. It's in personam and what else? Yeah. Not in rem, quasi-in rem. In rem jurisdiction, to go back to this, and this box is here. In rem jurisdiction literally means that you are suing me for this phone. All we're concerned about is ownership of this phone. And this phone is located here. And what it means is that if you're suing me for ownership of the phone, then the phone is present in the state. That's territory. That's penurial. That's jurisdiction of the place. Quasi-in rem is that you're not suing me for this phone. You're suing me for something else that has nothing to do with the phone. But you realize the phone is present in the state. So you try to attach the phone. And this will become clear when I talk about Schaefer in more detail. And you have to subject yourself to quasi-in rem jurisdiction. Okay? And if it's quasi-in rem, you have to engage in a minimum contact analysis. All right? So let's talk about Schaefer. I want to describe the facts so that everyone is clear about the missing case. The plaintiff owned a share in Greyhound. At some point, Greyhound engaged in behavior that caused it to be penalized for antitrust violation by the government. Being an owner of Greyhound, the plaintiff was upset because the plaintiff thought that the penalty caused the value of the company to drop and the value of their share to drop. So the plaintiff brought what is called a derivative action. A derivative shareholder action is when you're not suing the company, okay? You're suing the officials who run the company because you said they have taken some action or failed to take some action that have hurt the value of the company. Okay? Now, if you were suing the company, and we know the lawsuit is in Delaware, pretend that you are suing Greyhound. Would you have jurisdiction over Greyhound in Delaware? Just look at the facts of the case. It's not the derivative lawsuit. You want to sue Greyhound.
Yes, because isn't the company incorporated?
Exactly. That's an easy, determination. We know that you always have jurisdiction over a company that's incorporated in a place, right? But it is not what happened. They sue whether the individual board of directors of the company because they said those individuals took action that harmed Greyhound. So the lawsuit is not against Greyhound, it's against those officials to recover money that will go back to Greyhound. The problem is that all the officials that they were suing, the board of directors, were not located in Delaware physically, were not served in Delaware, were not present in Delaware, and were not citizens of Delaware. Right? So how did they try to get jurisdiction over them in Delaware? Yeah.
They tried to exert jurisdiction over the shares of the company.
Exactly. The shares are not real properties, basically pieces of paper that represent the shares, but under Delaware law, where were the shares deemed to be present? Yeah.
In Delaware.
Exactly. So it's almost as if it was a piece of land. So he's saying the shares are located in Delaware. So what did they do to the shares that the Penoyer lawyer didn't do? Yeah.
They attached it to the thing and then the court seized it.
Exactly. They said, oh, before I begin this lawsuit against these individuals, I'm attaching these shares. Once I attach these shares, is the Penoyer problem that was solved, the court has jurisdiction. That's a classic quasi-in rem gambit. Right? Now, how do I know that in fact it was quasi-in rem? Because sometimes it's not clear. The reason why you know it was in rem is because the guy wasn't trying to sue to get ownership of the shares. If he'd won his shareholder lawsuit, he wouldn't be given ownership of the shares. The shares would not be liquidated and the damages paid to him. That's not what he was trying to do. He basically was trying to get some sort of resolution as to the action that they took, right? In Greyhound. So therefore it's quasi-in rem. And we talked about this as the last thing that we talked about in class on Tuesday, right? In the majority opinion, written by Justice Marshall, what is the holding and the rule for quasi-in rem jurisdiction? Yes?
That it no longer exists to lapse into. So.
Exactly, which means that if you're trying to get jurisdiction over these individual people, right, and you cannot simply attach it, what analysis must you go through? Exactly. And it's not the minimum contact of the shares themselves, those maybe that comes into place to say, okay, what are the minimum contacts of this board of directors with Delaware? And the fact that they're on the board of Greyhound doesn't mean that it's enough, is it? Right? Because Greyhound may be incorporated in Delaware, doesn't mean that its board of directors meetings are in Delaware. It doesn't mean that when the board makes decisions, those decisions are taking place in Delaware. So chances are you would fail the minimum contact test. So as far as the court is concerned, right, you can see how by the time you get to the minimum contact part of the test, right, you have to make sure in your box that applies minimum contact, you're referring to non-resident, absent, non-consenting defendant, and quasi-in rem jurisdiction with the minimum contact. Questions? Okay. So now then, let's move, if you don't mind, to Burnham. Can someone summarize the facts of Burnham very quickly? How did poor Burnham end up in court? Yes.
So in Burnham, there was a husband and wife. Were married for 10 years, then decided to go forward with divorce proceedings. Wife moves to California. Man stays in New Jersey. And there seems wife asks the husband to proceed with the divorce, but he does not. And when he visits California to see his children, his wife serves him with, or his ex-wife serves him with process. And California says personal jurisdiction is valid.
Okay. Now, before we get to the ruling of the case, can someone explain to me, as far as the husband is concerned, what was the argument that he made that California should not have jurisdiction over it?
His residence is transient and and the action of suit is not related to his activity in that state, in California in particular.
So if he was trying to do a minimum contact analysis, right? What he was saying was that, number one, I'm not citizen of the state, so therefore you cannot get jurisdiction over me. Number two, I didn't consent to jurisdiction, so you cannot get jurisdiction under that. So the only way you can get jurisdiction over me is to look at the minimum contact analysis. Now, can we get through the minimum contact analysis and not just pretend the court didn't issue the decision that it did? If you're going to do a minimum contact analysis for for the husband, using the facts of the case, right? Can you take me through the steps?
I mean, I guess the first step would be purposeful availment, and the court in the,
Forget what the court does. Give me your own analysis. Do you think on the facts of this, you would check off the box for purposeful availment?
he was physically in the state, so he was availing himself of all of the fruits.
And he did that voluntarily, right? He did that voluntarily. He basically went to the state, and therefore, it wasn't as if he mentioned some other people. So what is the next question? Supposing it is a yes for purposeful availment. What is the next question you would ask? Yeah.
Whether it was foreseeable or not, of course, when you brought against him, that's it.
What do you think on the facts of this case? Forget about the result of the case, but on the facts that you have to be before you, what would you say? Yes or no?
I would say yes.
Why?
Because his ex-wife is in California. He's went to California to visit them for that specific reason, and he also was there for business.
What about the third question? The fourth question. Is he being sued for something that is related or arise out of the voluntary contact that he engaged with the state? What do you think?
I would say no, because he's not really being sued for what he did in the state. Like, he's not being sued for whatever he did regarding business. And he's going to visit his children, but he didn't get married in the state or anything.
I understand that. But what else was he doing in the state other than doing business?
He's visiting his.
Isn't the lawsuit related to that? I mean, what is the dispute between him and his wife? Yes.
Well, presumably in the divorce, custody over the children would be an issue, so visiting the children would relate to that house.
You could make an argument that it would have been different had he been sued in California while on business, but he didn't go to see his kids. Right? But it seems to me, and this is a counterfactual, this is not what happened, is that if you're going to make the minimum contact analysis, you might say, you went to the state voluntarily, right? You did so on the condition that it shouldn't be a surprise if you suit there having to do with your kids, but in fact, you are visiting your kids, right? So it could be arguably that you passed minimum contact test, but it is not what Scalia says. What does Scalia say, in his opinion, as to the rule that we're supposed to take from Schaefer? Yes.
Sorry, I have a question regarding that minimum contact analysis. Would you still argue that it's minimum contact if it's like sporadic one-off visits to their kids? Therefore, you shouldn't expect to get sued arising out of that.
That's a
one-off
great
visit.
question. The question then I would have to ask you is, do you really think that the visits to his kid fit in the sporadic line of cases, or is it a McGee problem? In other words, is it the case that this man, which I'm presuming is true, basically regularly visited his kids in California? I'm not saying that he did it every week, but I'm assuming it's not a one-off visit where he's only seen his kids once. Right? And if that is so, the lesson that you and I have learned from the cases is that the nature of the contacts doesn't have, you don't simply count heads to know whether they're systematic and continuous. You have to look at the nature of that and to see whether or not this is something that occurs on a fairly regular sort of way, even though it's not a lot of it. So yes, you could make an argument that it's too random, but it seems to me on the facts of the case, I can say no, parental visits probably occur on a more or less frequent basis, so therefore it is enough after McGee. So which goes back to my question. Did you have a question about this or my question?
Your original
Because I think a gentleman in the back, over in the back, wanted to answer my question, yeah. The question is, what did the court say? What did Scalia do?
So Scalia says that the state of California can obtain personal jurisdiction based on the idea that physical presence alone constitutes due process as is a continuing legal tradition within the American system, and that it's fair in that the gentleman here should have known and been aware of that as someone entering California, in that it's really just on him that he has no one else to blame but himself for not being aware that he could be brought into court based on physical presence.
Yeah. That's what Scalia says, look, it may or may not be true that California would have jurisdiction long arm based on minimum contact. But it's irrelevant. Because he says the fact of the matter is the Penoyer principle in terms of territory has never been overruled. So remember one of the very first questions I asked you during the class that we talked about Penoyer is whether you believe Penoyer is still good law. Does Burnham answer that question for you? And if so, what part of Penoyer is still good law? And what part of Penoyer is no longer good law? Yes.
The main part of Penoyer that is still good law is that when someone is physically present in the territory of the state, that they're subject to its jurisdiction.
Exactly. Now, if you really remember the full holding of Penoyer, which part or statement of Penoyer we know for a fact is no longer good law?
Clause A and Brett, for one, that one has clause in personal jurisdiction, as well as any kind of long arm, so whenever you have to apply the minimum contact.
Exactly. Remember, Penoyer said two things. Penoyer says that if you are inside the state has jurisdiction over you. But the second thing Penoyer says was that if you're not inside the state, then the state cannot have jurisdiction over you. We know that second part is no longer true since even beginning with Hess, but certainly with international issue in all the cases that it generated. Right. Now, the problem, of course, is that if you go back, right? If you go back and look at Schaeffer very carefully, Marshall seemed to have said that all jurisdiction analysis is subject to minimum contact. Right? What Scalia says in Burnham is to say, no, that's not quite what Marshall says. What Marshall said was that all analysis involving non-present defendant is subject to minimum contact. Right? But nothing about Schaeffer or any case since international issue invalidated the Penoyer principle. Yes.
So the two parts that's invalidated from Penoyer are, one, if you're outside of the state, you can't get specific jurisdiction. That's no longer true.
We know that since international issue, yes.
Right. What is the second point that it invalidates from Penoyer, though?
Well, I said there were 2 points. One that we meant true and one that is not true. The first point that we meant true is that if you happen to be inside of the state has jurisdiction over you, be it property or in person. Right? Questions? I mean, is that clear? Yeah.
This isn't a majority opinion. It's not a majority opinion, is it?
For purposes of cases going forward, it is true that the court has jurisdiction over you if you are serving that period. that has become the majority.
And that's the case because White and the other people who are concurring, they still concurred that you can still exercise it if you're in the president of the state, right? It's just they have a little bit different reasoning for that.
Yeah, so, but that disagreement in the reasoning doesn't change the fundamental idea. Here's the thing. Some of the justices who concurred in the judgment, in whatever fashion, said, look, why not simply use the minimum contact analysis to get jurisdiction? Because surely if the person is president of the state, you might get, but you see, here's the problem though with that reasoning that wouldn't account for it. As far as it is concerned, does it matter if you're president of the state for 5 months or 5 days? Does it matter if you're president of the state for 5 minutes? Yeah. Now, here's the thing. What is the reason, the policy reasons that Scalia offers to justify transient jurisdiction? Because I think that's important, yeah.
He doesn't want litigants to waste time arguing over over jurisdiction of the court. He wants it to get to the merits, and these rules are obvious for everybody going forward.
But doesn't it create the sort of perverse scenario that we were just mentioning? That all you have to do is to ambush someone on a layover trip, for example, even though the person is only there temporarily, and serve them.
Yeah.
Right? What policy reasons could you have other than the rule is clear? Yes, the rule is clear, right? But it does lead to perverse incentives, does it not? Yeah. Yes.
Could it be that they wanted to preserve like traditional notions of justice that like stem from like way beyond the even the Constitution, the 14th Amendment? He referred to like some Old English traditions where courts have complete jurisdiction of all their subjects within the realms.
But is that really a valid reason? I mean, I think that's one of the things that he says, right? Remember, this goes back to the very first class we had, in which, even in a memo, which has suggested that the basic idea is that the state is deemed to be sovereign, right? And just like a sovereign king or queen held dominion over all that he or she surveyed, both in terms of property, which technically belongs to the sovereign unless and until the sovereign gifted it to you. And just as the sovereign had jurisdiction over his or her subjects no matter where they roam, right? So too the state has become the modern sovereign, and therefore the state has jurisdiction. I understand the reasoning about tradition, but what policy value does it really have? What advantage does it give you that minimum contact doesn't have a better way of doing it?
It seems like in the very last paragraph of his opinion, he points to this argument about like federalism, that like if states want to change the rules about where jurisdiction is at, then it is in their power to do so, but unless they do, then it remains their right to do that.
That's one of the very important point that Scalia makes, because Scalia basically says it's always been a balancing test between the right of the defendants not to be subject to jurisdiction, right? That is inconsistent with the process, and the fact that we respect the sovereignty and the dignity of the state. And one of the advantages of sovereignty is the fact that you have jurisdiction over everything. But notice, it's something that you can give up if you want to. That's what Scalia is saying, as your colleague suggested. That the state could write a statute that says you cannot exercise jurisdiction over somebody whose only presence in the state is their passing through. And there would be nothing wrong constitutionally with that principle. It's easy, right? In other words, the state could give up jurisdiction if it wants to. Yes?
I'm having a little trouble hearing, and I was just kind of wanting to clarify on the point of the focus on voluntary versus involuntary travel and the reason why he traveled, as which one would be more important? Is it more important just to focus on the voluntary travel, or is it also in concurrence with the reason why he traveled?
Well, I just want to be clear. I was engaging in a sort of thought experiment in focusing on the voluntariness of the travel when I was pretending that we were going to analyze jurisdiction under the minimum contact test. Like, we're going to assume the only way we could have jurisdiction over this man was through specific long-arm jurisdiction, which would mean that we would say, first of all, is there a long-arm statute? Yes, there is, and it applies to him. Okay, fine. Has there been minimum contact with the state so that exercising jurisdiction over him would not offend traditional notions of justice and fairness? Well, for me to know that, I have to ask myself, did he purposely avail himself of contact with California? Did he voluntarily go to California? The answer is yes. The second question is, well, did he engage in contact with the state in such a way that it couldn't come as a shock to him if he was sued in the state? Well, he traveled to the state, his wife is in the state, he regularly communicates with them and the kids. He knows that they're engaged in a divorce proceeding. He knows that, basically speaking, part of the proceedings would involve custody of the kids. So I don't necessarily think it's a surprise if, in fact, there was some sort of lawsuit in the state based on that. And that answer to that question answers the final one. Well, does the contact that he purposely availed himself lead to or as a lawsuit? The answer is yes, because those contacts is about the marriage, the dissolution of marriage, the custody of the kids, which is what the lawsuit is about. So I'm saying that if I was to engage in a minimum contact analysis, the fact that he voluntarily traveled to California might be relevant. But Scalia says, I don't care about minimum contact. Presence is all that matters. So I'll go back to your question. If you accept the Scalia principle, does it matter whether or not he was in California voluntarily or involuntarily? No. All that matters is that he's in California. And Scalia says, if you want to change the law, change the law. But as far as I'm concerned, the state is sovereign. And a sovereign holds dominion over everything the sovereign surveys, even temporarily. Right? So you happen to find yourself in California, I don't care for how long or why. There's jurisdiction over you. There's no minimum contact analysis. You don't have to bother with that at all. So one reason is the sort of the clarity of the rule, but I think the other reason is that Scalia is pretending that he has so deep respect for federalism that he doesn't want to undo that fundamental federalist principle by taking away jurisdiction that state normally enjoy. Now, if you really believe that, that's a very important point. Thank you. Go ahead.
So I guess this last paragraph was kind of confusing, and I know what you're saying about how he's saying if states want to make a law to get rid of this tradition, they can. But then he goes on to say that the court can't like make a change because due process requires it. But I was kind of confused by that because isn't that what they've been doing in like every case that we've kind of looked at so far? Like, didn't Justice Marshall kind of make a change from Pennoyer to say that quasi-in rem is gone and then international shoe basically, like, why can't he make a change? Like, I get if he doesn't want to, but why can't he make a change?
Well, he suggests that in the opinion, right? And I think some of your colleagues already suggested that he's saying that this sovereignty principle predates due process. The sovereignty principle doesn't simply disappear just because of the process. So it involves some sort of balancing. Now, the reason why he says it's consistent with the process when we change the law under with the sovereignty principle under international shoe is that remember what Pennoyer said. Pennoyer said that territory is everything, so you only have jurisdiction if you're inside your territory, and you do not have jurisdiction if you're outside your territory. So it's okay to use the process to relax extraterritorial non-jurisdiction. You're not violating the state's sovereignty by doing so. Okay? That's how Scalia justifies it. Scalia says that due process as an idea did not invalidate state sovereignty. State sovereignty remained sacrosanct. But in instances where state sovereignty is not in play, as in extraterritorial jurisdiction, then we can rely on the due process principle to establish jurisdiction. You see what I mean?
Yeah, thank you.
And the last thing I'll point out to you in Burnham is that there is language in Schaeffer where Justice Marshall says, from this point on, all jurisdiction analysis, right, is subject to minimum contact test, okay? Which seems to contradict what Scalia says, right? Because he says, no, this is not. What Scalia does is to explain that what Marshall meant is all absent defendant jurisdiction analysis is subject to minimum contact. Because in the next paragraph, where Marshall says all jurisdiction analysis is subject to minimum contact, he says that, of course, in REM jurisdiction, scenarios would always meet minimum contact anyway. Right? That by definition, you cannot imagine a situation where the lawsuit is in REM that would ever fail minimum contact. It's because in REM means the property is in the state. If the property is in the state, there is no way, and the lawsuit is about the property, there is no way you can reason your way to say there is no minimum contact. Questions, comments? Yes?
So Scalia is basically saying state sovereignty trumps due process within the words of the state.
Yes and no. What he basically is saying that state sovereignty is the equivalent of due process, or due process is the equivalent of state sovereignty within the territory of the state. In other words, Scalia says, look, I don't disagree about that fairness business, right? You can talk about fairness all you want, but please understand that International Shoe didn't redefine fairness for in-state jurisdiction. The measure of fairness of in-state jurisdiction is the fact that it is in-state. It's not that in-state sovereignty trumps the process. It's just that in-state sovereignty is the measure of the process. Now, if you really want to reason through the opinion, right? Why do you think that Scalia can reasonably say, as a logical matter, that when the due process clause was enacted, it wasn't meant to trump state sovereignty when it comes to jurisdiction? No.
Oh, this is the 14th Amendment.
Yeah. But it basically says the 14th Amendment is ratified and enacted post-Civil War. It includes a due process clause, right? Post-1865. But it didn't trump state territorial sovereignty for purposes of jurisdiction. Why? What's the logic of that? How can you know that for sure? Yeah.
It was enacted by the states?
In part, but it had to be ratified by the state. But what else? Yeah.
The states, or at least the vast majority of them, already took transient residence to be enough to grant jurisdiction.
Okay, what else? In other words, what happens, post 1865 ratification of the 14th Amendment?
You didn't say it straight out.
In part, yeah. And also you have tons of cases post ratification of the amendment where time and time again states are exercising jurisdiction based on territory, and the court is saying, yeah, you're good to go. So therefore, had there been any, not only was there was no language in the 14th Amendment that excluded state sovereignty in terms of jurisdiction, but the court continued time and time again to confirm and reaffirm territorial jurisdiction. Right. So Scalia then can explain, and it's not really part of the opinion because the editors of the book excluded that discussion. But if you were to pull the full version of Schaeffer, there's tons and tons of discussion by Scalia about how the timing of the 14th Amendment meant it didn't mean to exclude state sovereignty.
Just do my pointing out which paragraph where Scalia is talking about sovereignty policy department. Try to find it out.
Oh no, I'm saying all the discussion I'm having right now, I'm conceding to you that it is not part of the opinion because the editors removed it from the book. But the full text of the opinion does contain a long, basic history analysis between the relationship between state sovereignty and due process. The only thing that Scalia says in the opinion is that the concept of state sovereignty predates and is older than the 14th Amendment. Yeah.
Yeah, but how much is it truly possible to reconcile like state sovereignty and due process? Like certainly you can I can conceive of cases where a state will exercise their sovereignty over a citizen in a way that violates due process, and surely that would be unconstitutional, would it not?
Yes, I don't want to go too far, which is what I'm saying, is that I'm not talking about state sovereignty in general. I'm talking about under what circumstances can a sovereign exercise personal jurisdiction in a court proceeding. And what I'm telling you is that, as far as Scalia is concerned, if you put Schaeffer Burnham together with Bernard, Scalia says, if the sovereign finds the subject or the property inside of its territory, then by definition is constitutional, assuming, by the way, that the notice provisions have been satisfied. In assuming the court has subject matter jurisdiction, etc., etc. All Scalia is suggesting here is that state sovereignty was never erased by the process.
That's his rationale for his ruling, right? Which is not agreed to by majority of the court.
What I can tell you is that subsequent to Schaeffer or Burnham, all courts agree that transient jurisdiction is jurisdiction. Period.
I guess we're kind of in the weeds here with
A little bit, a little
the
bit.
state sovereignty question, which
Exactly.
is not necessarily like I don't know, like it doesn't. The key part that we're currently debating or going over or discussing is the part that more than half the court didn't agree to.
That is true, except insofar as subsequent decisions, even while not agreeing with the policy rationale of Scalia, have said, in one way or the other, transient jurisdiction is jurisdiction because you can make the person fit minimum contact anyway. Because even if you're there temporarily, you're subject to the protections of the state. You are taking advantage of the protections of the state. Right? Yes.
So I understand that he's based this on this historical tradition, and basically saying like because it keeps being upheld, it makes it good law today. But as technology changes and things change, it seems like it opens up a possibility where these things do violate due process. Like you could think of, because we have people's social media, if you knew someone was posted that they were taking a trip to California from New York and they were flying, you could buy a ticket on that plane, be on the plane with them, and then serve them whenever they cross through the state. Just have the math on the thing. If you do that, like that, all these different things that were anticipated historically that have come up in the last couple of decades.
Yeah.
It seems like it opens up the door. Sort of
I do agree with you that if you were to take Scalia's reasoning or holding to a logical conclusion, it does create, as I mentioned before, perverse incentives, right? what Scalia is saying is that his rule has one overriding virtue. And the overriding virtue it has, above and beyond his historical antecedent, is the fact that it's clear. It may seem absurd to you, but it's clear. You don't have to be... Because the one thing that I know you all are frustrated about, and don't pretend you're not, because I can tell you're frustrated with it, even when I meet with you one-on-one, is that you basically are trying to wrestle to the ground the minimum contact test, and it becomes a very slippery beast. And you say, well, I understand what you're telling me, what the minimum contact test is, but it seems as if it changes with every other decision, right? And I can't really make much sense of McIntyre and Asahi because it could go either way, and don't even get me started on the pharmaceutical drug cases. So, and Scalia says, you know, that's what I mean. At least my rule has the virtue of being clear. I would say one last thing before we take a break and get into textual content. One of the things that some of you may know about Justice Scalia is that in addition to being an originalist, Scalia hated, with a passion, balancing test. And I think you're going to see that in con law, right? Whenever you give Scalia a choice, he really despised balancing tests because he believed balancing tests put too much power in the hands of the individual judges during the test. Because once I give you a bunch of factors and I say, oh, well, go ahead, dude, balancing them. You go, well, maybe you take a little bit of this, you'll take a little of that. And at the end of the day, you reach a conclusion, and nobody could say whether your conclusion was right and wrong, because you say, well, that's my balancing test. Right? Okay? And Scalia didn't like these rules, because he believed that these rules essentially usurped the power of the legislature and put too much power in the hands of judges. So therefore, in most instances, and you can be on the lookout for this in Congress if you want to, when given a choice between a balancing test and a bright line rule, Scalia tended to choose the bright line rule, right? And that's what he did here. It says, don't tell, this is one instance in which I'm gonna give up the nonsense of the minimum contact test. You inside the state, you're subject to jurisdiction. I don't care whether it's absurd. It's a rule, and you don't have to basically worry about writing a 2-page essay in an exam for me, justified.
Do we have to pick either Scalia or Brennan when we're understanding the rationale behind transient presence meeting?
I'm never going to ask you to really justify and pick the rationale. What I will tell you is that what I expect you to recognize is the fact that transient jurisdiction is a thing, and that in putting it on your chart, you should know which side of the page to put it in. Because transient jurisdiction is not specific long-arm jurisdiction. So, if you think about all the categories of jurisdiction we think about, that I've talked about, assuming notice is proper, what kind of jurisdiction are you able to exercise over somebody if you take Burnham seriously? Yes, all the way in the back. Yes, ma'am. Yes. Is general. That is so basically, those of you who are concerned about the absurdity of the rule, that should even cause you to be even more concerned. Because what you're exercising could mean accident. And nowadays, if you research Google on that, it's called tag jurisdiction. What you're exercising is jurisdiction over the person over everything just by the mere accident of they being in a state temporarily. But again, that's Scalia's philosophy. He preferred those bright line rules that didn't allow judges to basically ponder how many angels can fit on their head. Any other questions about this, how it fits in your chart, before we move after the break to the issue of so-called technological based contact? So you're all clear in your mind then as to where to account on your chart or your summary or your outline for Schaefer and Burnham. And you're all clear as to what kind of jurisdiction, right? applies when you're talking about Burnham, which is general jurisdiction, and what kind of jurisdiction that you're talking about when you're talking about Schaefer. Yes.
The property is transiently present in a state.
You're trying to spoil my wedding, my exam. You know. So every once in a while, if you talk to my former student, they will tell you that every once in a while they ask me a question in class that I refuse to answer because I want you to bring me the answer, right, in the next class. So I'm going to turn that question to you in the next class. Supposing you have a scenario where it's not transient people but transient property, is that enough for jurisdiction and whatnot? Okay. And even if you don't have access to Westlaw, right now, Google is such a powerful tool, you can actually research this in case. Yeah.
Does transient presence apply to corporations as well? Like, if one arm of a corporation is in a state?
That's a fantastic question. It's a beautiful question. And one that you're going to bring back to me next time. Does transient jurisdiction apply to a non-natural person, since by definition, a corporation cannot act on its own, and it acts for people? And is there a difference if, for example, the transient person that I'm tagging in California to get jurisdiction over the corporation that is in New York is simply a random employee as opposed to the CEO of the corporation? Does it matter if, for example, the CEO is in California because they happen to be on vacation on their honeymoon, or does it matter whether they're in California doing business for the corporation? Is there such a thing under any set of circumstances that you can think about that applies tag jurisdiction to corporate entities? Oh. So, 128, let's come back at 135 to talk about technological contact.
I ripped all my nails off.
Yes.
Alright, so why don't we resume? What we're going to talk about right now in the cases is something that I sort of covered over the edge of our discussion so far in all the cases when we talked about the modern world, the fact that the internet exists and all that. So there are a couple of things I want to say at the beginning before we proceed to the cases. The first thing that I want to say, which the casebook itself says, is that there is no, so far, maybe there's going to be one soon enough, there's not a single case issued by the Supreme Court that directly answers the question of how to engage in minimum contact analysis where the contact takes place or appears to take place completely online. There's no control in it. So if you were to look at the cases in the book, every single case in the book is from a lower court, district court or circuit court. So there's no controlling authority, big majority or otherwise. However unclear Asahi or McIntyre were in their reasoning, at least it was a case that was issued by the Supreme Court. There's none. So that will explain to you some of the uncertainty in that area. The second thing to also bear in mind is also this. At the end of the day, the analysis as to minimum contact when it comes to internet contact is not really different from minimum contact in non-internet settings. I know sometimes we talk about it as though it is, but it isn't. At the end of the day, you still come down to the same thing. So, when you're constructing your chart, it's not as if you have to have some sort of way over there at the edge of the board or at the edge of your page, something having to do with minimum contact over the internet. Right? Whether those contact takes place over the internet or not, okay, you're still asking yourself the same questions. You're still asking yourself first whether or not there is a citizenship off-ramp you can go to for the defendant. You're still asking yourself, in other words, if a defendant is a citizen of New York State, okay, and the lawsuit is about something they did over the internet that touches somebody in, say, California, and the lawsuit is brought in New York, the analysis is over. It has nothing to do with it. they're a citizen of the law, that's it, right? If, for example, it's something having to do with the internet, but they're tagged in a jurisdiction a la Burnham, doesn't matter, it's presence jurisdiction. If it's something that takes place over the internet, but it involves a contract that was signed over the internet, and there's a consent clause in the contract for jurisdiction, it's a consent analysis. The fact that it's online is completely irrelevant. Okay? The only instance where this becomes relevant is when you're talking about the minimum contact analysis. That it involves a non-citizen, non-present, non-consenting defendant. And there has been contact between that defendant and the forum state where they're being sued. And the person has never been physically in that forum state, or the majority of the contact took place online. That's it. So viewed in from that perspective, right, you could say, okay, why do I care? The analysis is still the same. My questions are still the same. Did you do so voluntarily, purpose of availment? Did you do so in a way that was foreseeable? And is the lawsuit related out of this context? Right? So let me give you an example, and I'm going to ask the class to analyze it. Okay. And I'm not going to use the example of a big company. Let's just say the defendant has an account on Etsy. Everybody knows what Etsy is? If you don't, tell me. Up until 4 years ago, I had no idea what the hell it was. I mean, it's a website that hosts individual businesses, mostly trade and all of that. And if you have an account on the website, somebody finds you, they click on your account, you offer a bunch of goods for sale. Okay. We're clear so far? So let's just say the person who runs the website runs a pottery business where they make cups and bowls by hand for sale. Okay? And when you go on Etsy, you click on the pottery business, their page comes up, you scroll through their products, and you find something that you like. You click on it and you put it in your cart, almost as if you're shopping on Amazon. Right? Once you put it in your cart, it asks you to check out. Right? And you check out. And in checking out, you know what information you're going to be asked, right? You're going to be asked to enter your name, right? You're going to be asked to enter your shipping address, right? Then you're going to be asked to enter credit card information, and you're going to be asked to put in a billing information, right? If it's the same or different as the contact information, right? And then you're going to click purchase, and then what's going to happen is that a few days later, or depending on the business, you receive your cup in the mail. On the same page, so that Etsy account happens to be located physically. The person is located because they went it at their home in Oregon, and they sent you the cup. You receive the cup, right? And you receive the cup in Florida, and you use the cup. And after using the cup for about a week or so, you find yourself becoming deathly ill, right? You go to the doctor, and the doctor basically gives you a test, and they determine that, in fact, you're suffering from lead poisoning because there was lead in the material they used for the cup. Okay? That's it. You've given all the facts. Can you sue the Oregon business owner in Florida? Let me go to you, yes.
Would you have to kind of see if this business specifically is advertising its product to Florida?
I've given you all the facts that exist. The business wasn't advertising in Florida because people who run Etsy websites don't advertise in that way. You were looking for a particular kind of cup. You entered the search in the Etsy search box. It brought up a bunch of people, and you found her stuff nice, and you bought it. You have all the facts. I cannot give you more facts. You can ask me questions, I'll answer them for you. But that's it. What do you think?
If you're in that case, then there wouldn't be a claim for jurisdiction within Florida if it's an online database that doesn't have a specific jurisdiction to which it's selling to or specific form of which it's selling to.
Well, I'm guessing that the Etsy shop sells cups wherever people buy them from. And I'm simply asking, and we can all agree here that I've removed the citizenship problem, I've removed the consent problem, because the Etsy terms of service didn't include the jurisdiction clause. And I've removed the sort of presence problem, so it's all minimum contact. I'm asking you, is there jurisdiction in Florida over that one? Yes, ma'am.
I don't think it would meet the standard like in Ford by Volkswagen if the defendant didn't take any purposeful action directed at the foreign state to like avail themselves of the benefits. There was nothing wrong. It was a unilateral action by the defendant ordering it, or sorry, by the plaintiff. They ordered it.
Really? And how did the plaintiff come about putting their name and address on the website?
The seller kind of entered it into the stream of commerce.
I'm asking you, how exactly did the defendant get my name and address?
I put it in.
I know, but why? How does the defendant do their business? Didn't they ask me for my name and address?
That's a requirement.
I know it's a requirement, but the moment that they ask me for my name and address, right? What do they know?
Where I live.
Okay, but for you that's not enough. That's fine. What is the next thing they did after I gave them my name and address and I paid for the thing?
They packaged it up, shipped it off.
To where, pray tell?
Okay. To the farm state.
So are you sure it's not personal available? Okay, so let's just say at least it could be, right? So what's the next step of the analysis of the personal available?
Foreseeability, is it foreseeable that you could be called to court there? Yes.
And why am I being sued? Because of the cup. So then why does it matter whether it took place online? Now, my argument would be, even for that one cup, I can sue in Florida. But I assume there's a whole bunch of people here who disagree. And if you do, I'd like to understand your reason. You disagree? Yeah. Okay, tell me why.
So I guess from the ex-ante perspective, you don't know whether this person is thinking the address is their domicile or just transit address, right? Maybe.
Well, I did ask you two questions on the thing. I asked you for your shipping address and your billing address. But you say even with the shipping address,
yes.
It could be that I happen to be on vacation in Florida,
Yes.
but I really live in Okay, all right. I love this. You're right. Supposing, because here's the difference though. Supposing you ship the cup to Florida while I was at Airbnb, but I live in New York. I go back to New York with my cup, I get lead poisoning. Can I sue you in New York? Same scenario. Exactly, because I agree with you, because I've just created which problem?
I guess foreseeability.
Is that I've created a worldwide problem, right? Okay. Is there a difference in your mind between the fact that you shipped the thing to Florida and I live in Florida, whereas the thing that you shipped the thing to Florida but I live in New York?
It doesn't matter because the company, the seller doesn't know, right? From the ex-ante perspective, how can he or she know?
So basically, you're saying to me, if I take your logic seriously, that this Oregon person can go around poisoning a bunch of people over the US and they can never be sued. Anywhere except in Oregon.
I guess maybe the regulator can say the platform have to have a disclaimer there, like say you have to consent before you ship your product.
Well, you're changing my hypothetical.
Yeah.
That's called fighting the hypothetical, and I don't want you to fight my hypothetical, I want you to accept it. And my hypothetical is that there is no such thing that you put in, saying that you said be shipping cups all over the country. But your logic is that wherever I ship that cup, I cannot be sued there because when I shipped it there, I didn't know it was gonna stay there.
Yeah, that's pretty much the rationale.
So Ben, so I'm asking you again, you comfortable with a rule that says, I can poison half of this class, but they can never sue me except to go back to Oregon?
In this particular hypothesis, yes.
Okay. Yes.
Like if I'm not mistaken, like in McIntyre, they did ship the machine to New Jersey, right?
The machine was shipped by the distributor, not the manufacturer. The manufacturer gave the machines to the distributor shipped it to Jersey. Yes, sir.
I may have missed this in your initial facts, but are we dealing with any type of long arm statute here, or is that irrelevant?
Assume that it exists and it's long enough. But you're right, I skipped that. Thank you for correcting me. It's part of the analysis, it's an easy box to check, but I'm glad you bring it up because it got missed by a lot of the charts yesterday. You always have to check the box, is there long arm statute? Yes, sir, there is.
So this is different than like just entering a product into a general stream of commerce because you're asking for someone's address and then sending it to them. It's like a personal transaction. Is that what you're arguing?
Well, that's what I'm asking you because we learned from Osai and McIntyre, stream of commerce is not enough. I didn't put this in the stream of commerce. I basically directed it toward Florida, and yet you still are letting me get away with it. That's purposeful availment. I don't see how it's not purposeful availment, yes.
Yeah, I was just gonna say that I think you can be sued in Florida. I think the question of if you take it back to New York becomes more difficult to answer, but I think regardless of whether you could take it back to New York, it doesn't change the fact that me as the shipper wrote Florida on the address, which I think introduces foreseeability.
Exactly. It seems to me that if I send it to Florida, you take it to New York, and I've basically created a worldwide Volkswagen problem. And it would be fair to say, well, no, you can't because it means that I can be sued anywhere in the US. Yes.
So there was a case in the technological context of reading Johnson versus Huffington Post where they talked about like just having a website that is available to a lot of people is not purposeful availment because it would be like having a store in New York, but because Texans came and shopped at the store and then they brought the product. So I'm wondering if it would change if the person had like a more.
Do you remember the set of facts that the court described in the Johnson case?
I only wrote the summary, sorry.
The case that it's talking about appears exactly at the bottom of page 201, if you want to turn to it, because all the technological cases start at 200. The Johnson case is on 201. Now I'm asking you, do you think that Johnson is the same or different than Manhattan?
I can see both sides, but I do think that the directed shipping, I think it does add a little bit more.
Yeah, certainly the directed shipping adds more to it. I guess the difficult question is that, what about if it happens even before the shipping, right? So, may I complicate the hypo a little bit, whether you want to fight it or not, right? Supposing what happens, same facts, the Etsy problem, except that the cup never gets shipped, right? The cup never gets shipped because she basically stopped doing business. And no, she refunds you the money. But, the information that you entered into a website gets stolen because she didn't secure a website well enough. And as a result, somebody takes your credit card information and charges a whole bunch of money. But can you sue her in your jurisdiction where you entered your credit card information and address? The shipping has not taken place. The only act that took place is the fact that you entered the information.
Well, that reminds me of the case with the insurance policy, I think, a little bit, because of the transmission of information, like even though it was just maybe one transmission, I think that was sufficient, like even though in the insurance one it was regular transmission, but that transmission was, and the lawsuit does arise out of that transmission of information because it directly involved.
But you seem to have difficulty with even that part of the question, because you said what made it clear for you is the shipping. I'm removing the shipping.
Yes, I think I misspoke, and I should have said that also the fact that there was an exchange of information between the two parties was material.
Yes.
I think McGee, the insurance company, is similar to the hypothetical before. You said when it was shipped, because they found that minimum contacts existed when they mailed checks and insurance information.
It doesn't concern you that in McGee it took place over a number of years?
Well, it's either like continuous and systematic or the nature of it. So I guess the nature of the one cup of poison.
So I have one more question about the poison cup, but I think you have a question from in the back.
I was gonna try and say that I believe that now that there would not be jurisdiction because it's no longer foreseeable that you could be sued in the Florida State Court based upon information that was stolen on a website that anyone could access.
I was gonna say, I think you would be able to sue based off of the fact that you would have known that that person's information was taken from that state, because you have to alert people when you take them.
So can we give one more twist to the hypo? Let's go back to the shipping. Let's just say that this was somebody who was trying to do this business, and this is the first and only cup they ever sold. And they never sold any other cup. So one cup. And the cup maybe was worth something like, she sold it for $35, you know, and it poisoned someone, and the person as a result suffered tens and tens of thousands of dollars of medical cost, suffered tens of thousands of dollars of lost wages when she was hospitalized, and of course suffered a great deal of emotional distress because A, no one wants to be poisoned, and number two, even though she's an adult, her doctors have said, well, chances are that is not going to have quite as much of an impact on you as if she were a child and your was still being developed, but it must still have an impact. So basically she feels, emotionally harmed. So this person sold this $35 cup one time, sitting in a garage in Oregon, is now being sued in Florida court for something like $250,000, $500,000, right? It's in federal court because it's diversity, and it's over $75,000. Does the federal court have jurisdiction over that person? There's a jurisdiction, yeah.
I think the amount of damages the person would be suing for would be irrelevant. It's just a matter of do they have jurisdiction over them. I'd say yeah, they do.
So you're okay with that $35 mistake? You're okay with her having to go from Oregon to Florida to defend this lawsuit?
Yeah, I could see the adjustment of the hypo maybe making it morally more complicated, but
you like clear lines, that it is what it is.
That's what I think.
Okay, yeah.
Yeah, I agree. I think the way I see it, it doesn't matter if it's the first cup or the 1,000th cup she sold, it's still the same situation regarding jurisdiction, because if we're looking at systematic contacts with the state, that transaction alone maintained the minimum contacts. No more contact was needed.
So, I'm sorry.
Did you say $50,000?
No, I said $250,000. I wanted to get over the 75.
That was my question.
I know you guys are on top of this. I think the gentleman had a question.
Right, just a question. So, can we draw an analogy, so to speak, between doing online business with, say, before the internet emerged, must have been some sort of national television or national radio on which businesses could intentionally put their advertisement and say, call this number or write to this number and you're saving some merchandise at what price. And I'm sure there must have been cases arising out of those situations.
I mean, yes. That's why I keep saying that the internet is a thing, is something like a glittering law that you think, oh, this must really change the analysis. It doesn't really. It's just a means of communication, a means of reaching consumers, the means of interacting with consumers that has existed prior to that, including over television or radio or all of that. So, you know, I'm sorry, you have a question?
Well, it's like, if we're thinking of the internet as just like life, right? So then we could just think of it as that seller is traveling to Florida to sell her product. The internet is really just like the means doing that. But like, it's like her setting, like if she set up a little table, Florida, and like sold you the cup, and that it was one cup that she sold, like you could use, and I get that she was there, like let's just, I mean, but like with the internet, that's, you're using that as your means to be present in the state ultimately.
So the way to think about it also is it's a version of the stream of commerce theory, except it takes place over the internet. And the one thing that we know, even with the uncertainty of Masagi and McIntyre, right? Even if we apply the heightened standard of Conrad as opposed to the lower standard of Brennan and Sotomayor, right? That says mere knowledge is enough, whereas O'Connor says no, you have to nudge the thing in that direction. The fact of the matter is, she nudged the thing in the direction of Florida. The fact that she used the internet to do it would not seem to be that much significant.
The court seems to struggle with a couple times in these cases is that like the internet is by definition omnipresent.
Yes, I'm glad you brought that up. And the courts have begun to so-called this out of the taxonomy, the Zippo rule, right? I didn't want to talk about the Zippo rule because before we talk about the Zippo rule, I think it's important to understand in the context of what I'm asking you to think about. I'm asking you not to accept this notion that somehow the internet itself substantively or fundamentally changes the nature of the minimum contact analysis. I don't think it does. Yeah.
So, I believe that on like Instagram, they have like a shopping portion of it.
Absolutely.
Where you could put in your information to Instagram and then shop with whatever account has products for sale. But they're not asking you for your information. Your Instagram is asking for it. So does that change the scenario that would the seller be liable?
Maybe. But let's at least talk about the Zippo factors first, and then we can sort of run your hypothetical through that. The Zippo factors, the so-called Zippo factors that I'm talking about here on page 200 to 201, right? And it's not the rule, because as I mentioned before at the beginning, the Supreme Court has not spoken on that. It's simply a lower court that had offered a three-tier factor analysis for analyzing internet contact, right? And the first part of the spectrum of Zippo is a defendant that we're talking about. It says, at one end of the spectrum, a situation where defendant clearly does business with the internet. If the defendant enters into a contract with residents of a foreign jurisdiction that involve the knowing and repeated transaction of computer files over the internet, personal jurisdiction is part. You don't have to think about it in terms of computer files. What they're basically saying is that if you run a business and you're engaging in contact with the foreign state, right, then that's simply normal business transaction that simply takes place with the internet, right? At the completely opposite end of the spectrum are the completely passive sites, right? Like I put up a website, maybe it's a blog post or what have you, maybe it gives financial advice. I'm not asking you to do anything. I'm not asking for information, but everybody in this room, wherever they are in the US or in the world, can access the website and get that information, right? And supposing that information somehow harms them in one way or the other, the Zippo factors would seem to indicate that there is no jurisdiction. But forget about the zipper factors. If you were to do a classic minimum contact analysis, why is it clear that there is no jurisdiction over you because you run a passive blog post that people can log on to and read? Yeah. Yeah. I'm not reaching out to any state, and we know, but why can't you make the argument that I've reached out to every state? Since I know by definition, anybody in every state can see it. I know you know the answer. Why is that an argument that can never win? Yeah.
There's like, I mean, throughout all of these, any kind of rule would like undermine the diversity of jurisdictions or undermine the principle of jurisdiction.
But there's a specific phrase the courts have used. Yes?
Cherry everything is cherry nothing.
Exactly. It's a form by form analysis. The court has never accepted the notion that you can target the entire US. That's a stream of commerce theory that alone is not sufficient. So by definition, if I cannot target the entire US market, if I'm shipping products to a distributor, I'm not targeting the entire US either if I'm putting a blog post. To target everything is to target nothing. The analysis for non-contact must be form by form. It cannot be the entire country. Right? So here, clearly jurisdiction, here, no jurisdiction. That's what the court says in its factors, right? At the opposite end of situation where the defendant has semi-posted information, a passive website that does little more than make information available to those is not grounds for extra jurisdiction. The middle ground is occupied by websites where a user can exchange information with the host computer. In these cases, the information, the extra jurisdiction is determined by examining the level of interactivity. Right? So, you run a website, it's a Substack, you read information in the Substack, you become a subscriber of the Substack, so therefore they have your name and they have your address. If the information is faulty and harms you in any way, are you subject to jurisdiction in a forum state? The analysis, by the way, ladies and gentlemen, is still the same. It is still the same. It is not different towards the internet. You still have to do the interactive part. Yeah.
What about I'm a little confused because I feel like most sites, even if they're passive on the internet, collect your information anyway. Like any site you click on is like accept all the cookies so we can sell your data. So it's like I feel like they make it as passive as possible so you don't know what's happening, but there is some interactivity happening.
That's right. So it's the hypothetical that your colleague posed to me. So let's go back to it. It's the Instagram problem, right? Have you ever noticed that when you log online, maybe Instagram or whatever it is, that sometimes you have ads that seems to be specifically targeted toward you? Sometimes they're general. For example, they said Virginia residents must learn of this wonderful mortgage trick that just became available, and you happen to be in Virginia. So you said, oh, I'm going to click on that, right? Okay. Now, this is the Instagram problem, right? Now, let's just say you found this in Instagram. Right? The Instagram simply hosted the ad, and you click on it. Supposing there's something wrong, who can you have liable in Virginia? Instagram or the ad company itself? Or cookies themselves, the fact that they simply hoover all the information for everybody, is it enough? Right? Because aren't cookies by definition targeting everything? And somebody just told me to target everything is to target nothing. Yeah.
Wasn't there the Mavericks photo versus brand technologies case where they sold ad space? So you would have to do it.
The case that you're kind of referring to appears on page 2 or 3, and it's note 4. Yeah.
Yeah. So but I think in this one they knowingly sold the ad space. I think with the knowledge that the information would appear in California. So I think that's probably the thing that it hinges on is did you knowingly.
But I'm glad you said that, but notice the analysis again is not different. Notice that what the court is talking about is really purposeful availment and foreseeability. The medium through which this thing is taking place is not really that big of a deal. Yeah.
targeting everything like the United States in general and targeting each state specifically. Like they could target all 50 states, but target each state, and it's different than just saying I'm gonna put my product in the stream of commerce in the entire United States. Like if they're collecting your cookies and to see which state you're in, it seems like they're purposely failing themselves to whatever state you're in. Those rooms.
Yeah.
Are you saying that the Zippo test is really just fictional and it's just the minimum context test?
First of all, the zipper test is not really a test, right?
Middle ground.
No. What I'm saying to you, the Zippo analysis, the 3-tier factor analysis of Zippo, is merely a way to guide you through the minimum contact test when the internet is involved. Because notice that if you look at each step of the way very closely, all it does is rephrase the minimum contact analysis. Now, it doesn't necessarily mean that I cannot create a whole bunch of scenarios that make it difficult to apply the analysis, right? It's not just collecting cookies, but particularly with geofencing, etc., it becomes minimum contact. But the question still goes back to asking you, is there minimum contact? And that question, you know what set of questions to ask yourself. Now, what happens is that the casebook between pages 200 and 207 reproduces a number of cases in short books, right? And we can spend time talking about these cases, though I don't think it's necessary. What I can tell you, you'll notice, is that you will not be able to read these cases and say to yourself, I can put all these cases together and come up with a coherent rule. In part because these cases are from lower courts, each of which are deciding their cases based on what they think is right? What these cases are designed to do is to give you examples of the way it applies. But there is a case that they should have included in the book. They're bad editors for not including the book. The case came down 2 years ago because I think it's a great case to include for a certain case. It's my case. Right? It's a case that, because I want to talk to you about that case because to show you how the process really works. And we talked about it before, right? It's a Brennan Gilmore problem where the Charlottesville young woman who got run over by the car during the protest. Brennan is there, he's on site, he films it, right? And once he realizes what he has, he puts it on the internet. A bunch of news channels call him and agrees to it. Brennan used to be an employee of the State Department. He began to work with the State Department overseas after finishing his stint with the Peace Corps. And then he took time away from the State Department to go into Virginia politics because he's concerned about the environment, and he became an environmental activist, which he still is to this day, right? Okay, so it puts, that's why he happened to be in Charlottesville that day. So he puts up the video. Immediately after he puts up the video, it gets picked up by InfoWars and Alex Jones, and it gets picked up by a whole bunch of other right-wing websites, and they begin to talk a whole bunch of conspiracy theories about him because they said that, in fact, he was never really part of the State Department. It was a cover. He was a CIA operative. I can assure you, Brennan is my client. He was truly part of the Peace Corps, and he was never a CIA operative. And that the accident never happened. She was never killed. It was a crisis actor. All the usual stuff that sometimes Alex Jones used to travel, right? Brennan begins to get flooded with tons of threats online, all over the place, from all sorts of sources. He has to take his Twitter account private. He has to shut down his Facebook account. And at some point, the threats migrate into real life, and his family receives an envelope with a white powder. They open the envelope, not realizing the powder in there, and they freak out because they think it's an American threat. It turns out to be a sort of harmless powder. But Brennan is pissed because he believes that his reputation has been trashed. So he decides to bring a lawsuit. Like, he decides to sue everybody, including Alex Jones. Alex Jones and InfoWars are located in Texas. Brennan doesn't want to sue Alex Jones in Texas. He wants to sue Alex Jones in Virginia. So he filed a lawsuit in the Eastern District of Virginia. Right? So you and I know what is the first argument that Alex Jones is going to make. Alex Jones and InfoWars, both as individuals, as a company, say, hey, whatever do, you have no jurisdiction over me. Right? You have no jurisdiction over me because you didn't serve me in Virginia. I'm never present in Virginia. I'm not a citizen of Virginia. I'm a citizen of Texas. So the only way you can get jurisdiction over me is if, right, is if you have minimum contact. Right? And you can never win the minimum contact test because, by definition, if you can sue me in Virginia because of the thing that I wrote about you, then anybody can sue me anywhere. Right? And you can look at the decision, the lower court and the Fourth Circuit didn't take the case, said there was jurisdiction in that case based on minimum contact. Can you speculate as to why there was jurisdiction based on minimum contact in Virginia? Yes?
Because he said Virginia in the defamatory statement.
Yeah. He basically identified Brennan by name. He told the internet where Brennan lived, not the exact address, but the state. And he said that the CIA covert operative is operating in Virginia and using crisis actors to establish this fake narrative. And the court said, okay, let's do minimum contact analysis, right? Did you purposely avail yourself of contact with Florida? Yes, you did, because you happened to name a citizen of Florida in your article, not Florida, Virginia. Did you do it in a way that was foreseeable you might be sued? Well, you said you talked an awful lot of shit in that article. Right? So therefore, you shouldn't be surprised. Was the lawsuit about this? Yes, it was. So check, check, and check. It had nothing to do with the internet. It was a classic minimum contact analysis. Yeah.
So it wasn't affected by the video that Brian posted. It was about the content of what the defamatory article said.
Exactly. It was because the action that the court focused on wasn't what Brennan did. Remember, the analysis is about the defendant. So the point of the analysis was, what did Alex Jones do? Yeah.
Wouldn't it still pass minimum contact though if he went to this site that's hosted in Virginia and grabbed the video? Do you know what I mean? Or is that
I don't think that it would, because you could grab the video, but it doesn't mean that you are targeting Virginia. You know what I mean? Like if let's just say the video was posted on Brennan Twitter account, and all I did was to go to his Twitter account and grab the video, I'm not sure that would have been enough. Lots of questions. We can start here and go around. Yeah. Go ahead, yes. And then we'll go this way.
So if like the minimum contacts is fundamentally not different for internet cases, then why do you think that there's no coherent rule for those cases that we look at?
A couple of reasons. Number one, in one case called Weldon versus Fiore, Justice Thomas speculated, without saying anything more, that perhaps we were to begin to think about minimum contact differently because of the internet. It's the sort of thing that justices sometimes do because they want to sound big brain. But, I mean, whatever, it doesn't mean anything, right? So lower courts have run with it, but the lower courts, notice, are not announcing different rules. They're simply coming up with different results based on minimum contact analysis, which is fine. It's not as if you can predict what the results are going to be based on minimum contact. They come to, so as if it's not different, but everybody is sort of on edge about this because the internet. And once Justice Thomas said that opinion, it triggered something that happens all the time. Law professors get tenure because they write articles and publish it. You always want to publish something that you pretend nobody has ever thought about. So everybody wants a sea of articles about the internet and minimum contact. Doesn't really mean that much. It's still the same analysis. Yeah.
Could you explain again why merely mentioning this guy is from, or saying this guy is from Virginia means that he's targeting Virginia? Because,
targeted a citizen of Virginia.
Right, but in terms of purposefully availing, presumably we're talking about the fact that he's producing content in order to sell, in some form, right? And the customers, I can think of kind of instances where you're gonna talk about a place, but your real audience isn't that place, or your real audience is much broader, there's not. Or maybe what did Jones's lawyers say? What were their counter-arguments?
Their counter-argument was that the mere mentioning of the name wasn't sufficient for minimum contact, right? Because sometimes in blog posts or whatever, you can mention a lot of things. The reason why this case was different is that he wasn't merely mentioning Virginia or mentioning somebody who lived in Virginia. He identified Brennan by name and he identified Brennan by location. So as far as we're concerned, what he was doing was targeting a citizen of Virginia, and now he's being sued in Virginia for the thing that he said about that citizen of Virginia. To us, that was a very, very specific form of targeting that met the minimum contact analysis, because we've learned since McGee and Henson that it's not the number of contacts that matters, it's the nature of the contact.
But what if there was no internet and Jones and Brendan met in Tennessee or something, or neither of them?
They met where?
Tennessee, just some state that neither of them live in.
Okay.
And Jones was kind of at the bar, just like making fun, making up stories about him, or walking around town telling people stories about him. Would Brendan still be able to get?
That's a great analysis, and the analysis actually is answered by the gambling Nevada case, where they basically are traveling after winning things in the casino. They get stopped, their money gets seized, and they go back home and they sue the agent back home. Because that's what you're saying. You're saying that basically Alex Jones meets Brennan in a bar somewhere in Texas, right? Brennan tells Alex that he's from Virginia. They get into a fight and Alex punches Brennan. Brennan goes back to Virginia and sues Alex in Virginia. Is there jurisdiction in Virginia? The answer, it seems to me, based on your analysis, and you and I both know is true, is no. Because the mere fact that I punched you in Texas doesn't mean that I foresaw that you could sue me in Virginia just because you happen to be in Virginia. Because the harm occurred in Texas. Here, the difference in my case is that the harm occurred in Virginia to somebody in Virginia. Yes.
So I know that you said that this case should have been in the casebook, and I agree, but the one that I see that
I know, it's an upgrade.
I agree, but the one that's in here is Twin Flames versus Cole, and that's someone who posted something mean on Reddit, but they didn't mention the state of Michigan, they only mentioned the business practice. So could this be seen as maybe, I think it could be maybe even persuasive for your case, just because they didn't mention.
Yes, mine is better than that one. I don't know why that one is in there.
So it is related though, okay, alright.
I'll post the opinion for you online. It's a great opinion. No, we made law in the Fourth Circuit because the Fourth Circuit declined to review the decision. So that I can promise you, any case where jurisdiction is premised over the internet that occurs in any court that is cited within the Fourth Circuit is going to cite to the Gilmore case. Yeah, you have to. My clinic students are that good because they litigated the case and they were the brief, not me. Yeah.
So for, say, a newspaper like the Washington Post that has a national audience, and they often write articles about people all the time, does that count as targeting?
That is hard. That is hard. It depends on the level of information. The fact that you've made it Washington Post doesn't give you the answer, because that was one of the arguments that Alex Jones made. Because one of his defense was that he's basically a journalist. It's a First Amendment issue. The fact that you don't like what he says, right? The fact that you don't agree with him, that the government is putting chemicals in the water that makes frogs gay. No, he actually said it. Oh, he said, I'm not making it. It doesn't matter whether you disagree with him or you think it's funny or whatever. It's still free speech journalism. That itself is not, that never gets you the jurisdictional problem. it may be fairly different. So making it the post doesn't matter. It would depend on what the post says and how they said it.
Well, I'm thinking more, say, there's a viral video, the individual is relatively unknown until a national newspaper picks it up and talks about the individual, but it doesn't mention the state the individual is from.
If I don't mention the state, then I've not targeted that form, particularly if I don't even know what it is. Yes, and I'll come to you. Yes,
So if there was like a advice blog, and they say like to New York residents, here's my advice, like whatever, and then someone follows that advice and gets heard in New York, would they have personal jurisdiction over the blogger because they directed that?
I don't know. What I can tell you is that it's not some sort of mysterious question. And I know now, I should leave the poor horse alone because the horse is already dead. What I'm saying to you is that all you have to do is to use the tools you have to answer the question. And the tools are not different just because it happens to be an the question I come to.
Is there an element of sport fulfillment that person is like enshrining themselves in their like I understand what the Alex Jones case, the first the aspect is, I was able to found an article, but I'm not really seeing
It's a great question. That goes to show you that there's a lot of policy reasons that the court advances to justify the minimum contact analysis. One of which is, oh yes, it's fair for me to exercise jurisdiction over you because by making contact with this, it's somehow you're being protected by the laws of the state. No, it's a sort of legal fiction. That in reality, you and I can come up with any sort of scenarios where I'm not really getting any protection from the state, but it's like the poor woman in Oregon, right? The argument could be made that, the reason why I can sue you in Florida is because if it happened to be that the person who bought the cup for you broke her word and canceled the charges, and Florida would give you, as the business owner, a wonderful forum for which you could sue our own resident to collect your money, right? So in some sense, you're availing yourself of the protection of our jurisdiction. Yeah, it's true in theory, it doesn't really happen in practice. So the idea that, well, the reason why is because you're availing yourself of the benefit of the forum, in theory, every single time you make contact with the forum state, you're assumed to be availing yourself of the benefit of the forum. Does it really happen? Yeah.
I was gonna ask a question about the hypothetical, specifically in your case versus like an example of the Washington Post or something like that. Isn't it a specific point of fact that what Alex Jones is saying wasn't true?
No.
That doesn't matter in terms of like.
It's an affirmative defense. In other words, it's something that goes to the merits of the case. We didn't get to the merits of the case. The case ultimately, Alex Jones settled with us. But the merits of the case is, what was he saying, true or false? It doesn't matter. For purposes of jurisdiction, that question is put to the side. You have to take the facts as they are. So for purposes of jurisdiction, the court simply assumed that everything we said in our complaint was true, because at the time the jurisdiction problem came up, it was moving on to 12b6, which you assume that everything I said is true, and then you ask yourself, well, is there jurisdiction? Yes, I'll come to the back in a moment. Yes.
Just one quick clarification. So I presume we can draw parallels between your case and the Keaton case, because both. But I think one important fact in Keaton is that there was, I think, 10 to 15,000 circulations per month in New Hampshire, even though Keaton wasn't necessarily as in New Hampshire. So in your case, does it matter that some audiences of Alex Jones are within Virginia?
No. I think it's a great way of thinking of it, because you get to the heart of the matter. In some ways, it does